name's Thomas Eineman. I am a circuit court judge in Hernando County. And currently at this time, part of my assignment is the Unified Family Court. I'm just going to start out with some statistics to give you an idea of the kind of volume we're dealing with. In the year 2015, which was the last year I could find statistics, there were just shy of about 167,000 marriages in the state of Florida, and there were approximately 80,000 divorces during that same year. So statistically, the divorce rate is something on the order of 48% at this time. And from what I could glean in my research, that percentage has been fairly constant for a number of years. So the point of that is there's simply a lot of family law cases going on, and that's just divorces. Of the divorces in the year 2015, approximately 40% of those affected children. People had children, and the court had to deal with custody issues as well as other issues. A few more statistics. Currently, if you eliminate the county court, if you eliminate the landlord-tenant cases, the misdemeanors, small claims actions, eliminate that, and then look at what is left, the circuit court filings, just shy of 40% of all the filings are somehow family court matters. That's quite a large number. And if going back a little historically, if you look at the last 17 years, again, eliminate the county court matters, but again, looking at just circuit court filings, for the vast majority of the years, circuit court filings, family court filings were the largest percentage of all the circuit court filings, something to do with family law. Another statistic is one thing I experienced even in private practice, but certainly as a judge, is that the number of paternity actions has simply exploded, where courts are called upon to decide custody issues between folks that were never married. They had children but were never married. And that simply has exploded. And I found some statistics. If you go back to 1980, less than 25% of all children born in Florida were to an unwed mother. That has expanded over time, or increased over time. To the year 2015, where just under 50% of all the children born were in fact born to an unwed mother. That certainly has led to a big increase in paternity actions. Another type of action that has certainly seen an increase is what we call temporary or concurrent custody actions by an extended family member. And it's not at all uncommon that we have young people not married. They have a child together. That's the last thing they frankly are prepared to deal with. Maybe there's drug issues in the mix, but in any event, they are not able to care for the child, and the grandparent may come in and file an action for temporary custody with the idea that the parents will get on their feet and get their act together shortly. But I've seen a huge increase in the number of those actions as a judge. Just a little historical matter, because we're here to talk about the Unified Family Court. That's really been developed over the last 25 to 30 years. Back in the year 1990, the legislature passed an act basically establishing what might be called a Family Courts Commission, which was supposed to study and make recommendations on how to have a family court system, a good family court system throughout the state of Florida. And ultimately, the Supreme Court began establishing or passing, entering a number of opinions to do just that. Beginning in '91, the Supreme Court basically mandated that every circuit in the state, and we are in the Fifth Circuit here, but every circuit in the state would need to adopt a local rule establishing a family court. And of course, Hernando County did that. Also at that point, the Supreme Court indicated that when judges are assigned to the family division, you want to try to give consideration to a judge's interest, his or her desires, willingness to serve in the family law division, because I'm guessing when I look here, every judge in the room either is now, or has in the past handled a family law docket, and it's certainly not an easy docket to handle. You see people that are very stressed out, often very emotional. So the Supreme Court indicated that you really want to assign judges who want to do that type of work, because they will need not just to know the substantive law, but they're going to need, for example, substantive divorce law, that's fine, but you're also going to need to know other areas of the law if you're going to handle a unified family court docket. The Supreme Court also indicated that if we're going to have family divisions, that we need to make sure we give court services such as guardian ad litem programs, mediation programs, domestic violence assistance programs, which certainly has happened in our area. Another concept that the court wanted to kind of have the Florida courts develop is what might be called a therapeutic approach or holistic approach, just recognizing that a family's legal problems may not be the big problem going on in the family. You might be seeing them in a dependency action, but the reason they're in dependency court is because somebody has maybe a drug issue, possibly a mental health issue. So the Supreme Court said attention needs to be given to trying to address a family's both legal and non-legal issues. And going further, this will be the last history, I promise. In 2014, we still have what is referred to as the Florida Family Law Rules of Procedure, but in 2014, some additional rules were added which really flesh out the unified family court concept. Number one, the same judge is to handle all related family cases. So what that means is, for example, if today I didn't, but if I had a domestic violence case and I entered a final judgment between a husband and wife, and let's say a month from now one of those two parties files for a divorce, that case will be assigned to me as part of the unified family court. I don't handle all the divorces in the county, but it will not go to one of the other two judges. It will go to me under the unified family court concept. I've never done this, but in actuality, a court can order joint trials or hearings. In theory, I could have a divorce trial and a domestic violence trial involving the same parties on the same day. I've never done that, but conceptually, it can be done. Now a judge can review a file of any related case, whether that file is closed or not. So if I was taking on a divorce action today, I could review a domestic violence injunction case that may have happened 2 years ago or 2 weeks ago, whatever. Parties have to fill out what's called the notice of related cases, indicating in writing what other cases they're aware of that involve the same parties. Candidly, you cannot always count on them doing that, but they are supposed to do that. Well, some of the unified family court principles, I've touched on one family, one judge. So I, as a judge in the unified family court, I could handle a family's divorce, a domestic violence hearing, and also a dependency hearing. So the idea, again, I'm going to know the family better if I am seeing them all the time, as opposed to on Monday they'll see Judge Eineman for their divorce, and on Wednesday they'll see a different judge for their domestic violence hearing. The Unified Family Court is based on what we call comprehensive subject matter jurisdiction. The types of cases that family law can cover is really quite voluminous. You have dissolutions of marriages or divorces, annulments, support unconnected with divorce, paternity, child support, uniform foreign support acts, adoptions, concurrent or temporary custody by extended family members, declaratory judgment actions on the validity of a premarital agreement, dependency actions, and of course what we call modifications of existing orders. By that I mean certainly in the real world, I will tell you, if a couple is getting divorced today and they have a couple of children, just say 5 and 8 years old, you can almost be assured you are going to see those people in the next 10, 11 years concerning one or more issues that are subject to modification, be it child custody or child support. I touched on this earlier. Unified Family Court, you want committed and engaged judges, magistrates, and hearing officers. Magistrates are what is sometimes referred to as a quasi-judicial officer, but they can handle a lot of matters in the dependency court and also matters in divorce court that are referred to the magistrate. They tend to be able to get matters resolved a little bit quicker than a circuit judge. But again, the whole point is you want judges that want to do it. Next, we have case management behind the scenes. I mean, I'm in the courtroom, so I don't really see what's going on behind the scenes. But needless to say, behind the scenes, you have a lot of court personnel that are helping out, primarily, among other things, identifying cases that should go to the Unified Family Court. So, again, it's not just a notice of related cases being filed by parties, but we actually have court personnel looking into making sure the case goes to the right court, which would be the UFC. And technology is very important. Without it, I don't know how you would be able to handle UFC court and frankly other courts too. But for example, the technology, you have automatic calendaring. Notices can be kicked out automatically. For example, a failure to prosecute, the folks will get a notice if there's no action after a period of time, indicating to them that if they want to move on their action, that's fine, but they need to file something to get it going. Technology helps out there. It obviously can maintain a complete history of a family's involvement in the court system, keeps statistical matters if that needs to be examined. And also very important, at least from a judicial perspective, nowadays we don't have files, and at least here we don't have files in the old-fashioned sense of the word. It used to be, before I was a judge, you could get your daily docket of files sent up from the clerk, and if you wanted to hide behind those files so no one would see you, you could do that because the stack would be 2 feet deep. Well, now we don't do that. Everything is computerized. So if you're like me and it's a Sunday morning and you can't sleep, if you have the internet at home or wherever you are, you can actually access your docket for the whole coming week and look what's on your plate and decide what, if you need to do research or whatever. You don't have to come to the courthouse. You don't have to, carry a bunch of files around with you. Those days are over. You can just simply look on the computer. And of course, we want to make sure that services such as drug counseling, mental health counseling, that sort of thing, if the folks qualify for that, that's made available to them, and court personnel help out greatly there. Obviously, to make UFC work, there has to be collaboration between all the players, not just the judge, but the providers of the various services, the folks that provide drug counseling, mental health counseling, that sort of thing. So everybody's kind of working together to not just, again, solve the legal problem that the family may have, but maybe some of the underlying problems that lead them to have the legal problems. Certainly we have now a huge explosion in the number of self-represented litigants, and forms are certainly available to help people. That's another UFC principle. You can file your own divorce with a kit. The clerk is available with the forms for domestic violence as well as other civil orders of protection, and help people in that way. They don't give legal advice, but they can provide guidance on getting the forms filled out, and also referrals for legal services. Maybe someone's going to file for divorce and they want to know the name of an individual that does pre-filing or simultaneous filing mediations. The clerk can provide that kind of information to that person. Another UFC principle is to try to make decisions on what we might call a little non-adversarial approach. So it's not just, a judge in his or her courtroom, people come in, testify, boom, judge makes the decision, and that's the end of it. One of the big, if not the biggest, process used is mediation. We use it all the time in divorce court. I believe it's used quite a bit in dependency court, paternity actions for sure. Basically, that's just for the public. Mediation is where you meet at on a date, place, and time certain with a mediator and the other side, and the mediator's there to try to facilitate and broker an agreement. A mediator cannot force anybody to do something they don't want to agree to. They certainly have a right not to enter into an agreement, but it certainly is a good process. We do not, of course, mediate domestic violence cases. When you think about it, that would be inherently silly. But pretty much any other type of case that I deal with, it is going to go to mediation. The comprehensive information we'd already touched on. Again, if I'm the judge hearing or seeing the same family, I'm probably going to have a more comprehensive picture of that family then if we piecemeal it and I'm doing something, Judge Toner's doing something, Judge Neal is doing something, at least that's the concept. And what are some of the benefits of the court, the Unified Family Court? Presumably, the family would have enhanced trust in the court system. At least that's the theory. Certainly as a judge, we know that approximately 50% of every case we see, the folks don't like what we do by definition. Half the people don't agree with our decision. But I believe it's fair to say that if I'm seeing the family again and again on any given day, that one party may not like my decision, but they probably would feel that I made the decision with more information available than if I, again, was part of a piecemeal process. We certainly have fewer hearings because, again, you don't have to come to court Monday for your divorce, Thursday for your domestic violence hearing. It could all be done at one time on the Unified Family Court docket. Hopefully there would be what we might call more consistent orders if I'm entering orders for the family, albeit maybe in a different type of case. My thought processes would probably be more consistent as opposed to how I see something. Another judge may see an issue differently. So we believe you will get more consistent orders by having the same judge deal with the family. And again, lastly, I've really touched on these two. The whole point of the Unified Family Court, or many points, but is to have full information available to the trier of fact, which, again, if you deal with the family, and I will say, Judge Merritt, who makes the assignments, I'm quite confident in saying our Unified Family Court, in the half a year I've been doing it, is greatly expanding. I can't quantify it in terms of the numbers, but I believe it is growing, to say the least. But does anybody have any questions? No questions? You're killing me. Okay, thank you.